Okay, so welcome to my presentation about Ezra and an end-to-end system for re-identification and anonymization of Swiss court decisions. This work is being conducted as part of the NRP 77 project, Open Justice versus Privacy, which is a collaboration of lawyers and computer scientists at the University of Bern. So what is it about? We are in the balance between an open justice system and the people's privacy. So court rulings should be public to facilitate jurisprudence and make this justice system accountable. But on the other hand, privacy is a fundamental human right. So because of this, court decisions in Switzerland are anonymized right now. But this happens mostly manually, which is expensive, error-prone, and not scalable. Additionally, there is the risk of re-identification. So on the right side, you can see an example from Sweeney, where they were able to link two databases by the means of date of birth, sex, or zip code, even though both were anonymized. A similar work managed to re-identify 21 of 25 highly specific court cases in Switzerland by linking external data. So they did a lot of pre-processing and it was a lot of manual work, but it was possible to re-identify a large part of these decisions. So in our work, we want to extend this to make it more general and applicable on a larger amount of cases. So the goal of this is to find out how high the risk of re-identification is. So for this, we have the research question 1, which is for what percentage of anonymized Swiss court decisions is it possible to re-identify entities, and what is the effort required, and to what extent can it be automated? So on the right side, you can see a high-level overview of the process which we plan to use to perform this re-identification. So it's a combination of the court rulings and the external data, which where we will extract the information to build knowledge graphs and perform record linkage or ontology mapping. But more on this later. Leading on from this first research question, we get the second one, which is how can the findings of this re-identification program be used to strengthen existing anonymization procedures? So again, on the right side, you have a quick overview. So we plan to use the re-identification results to provide guidelines to the courts and influence the anonymization process. This is another overview where the re-identification tool corresponds to the verification tool, so we can verify if a court decision is anonymized sufficiently with our tool, so that it can be released, or we can perform a cost-benefit analysis. So what are challenges in our project? So far, there is almost no open curated data available in the Swiss legal domain, unfortunately. There is the government and other entities, they publish the data, but it is not ready for use in NLP. Additionally, in Switzerland, the landscape is the political landscape is very fragmented. We have 26 different cantons, each with different regulations, laws, court systems, and so on. And these cantons are further divided in 3 different languages. Some of the cantons have more than 1 language. Also in our data set, we have all levels of appeal, so it encompasses the entire landscape of decisions in Switzerland. Additionally, the languages are not English, which makes it a bit harder in NLP because of less available resources and pre-trained models and so on. Also, of course, like you all know, we have the specialized legal language. So here I am presenting you the proposed methodology, which we plan to use in the next 2 to 3 years. So first, we plan to obtain and curate a data set of Swiss court decisions. Then to process these court decisions effectively, we want to pre-train a language model on Swiss legal data in general, and then annotate Swiss federal court decisions with named entities, so we can recognize them easily because they are most important for re-identification and anonymization. And finally, with these entities, we want to re-identify the anonymized ones. So here we have 2 solutions, which I will explain also more in detail afterwards. So the first one being we just search for with identifiers we extracted in the external data, or otherwise we perform the ontology mapping of 2 knowledge graphs. So the first step is already done, or most of it is already done. So we collected the data set, we pre-processed it, and we are still working on extracting relevant information from the decisions. So just to give you a quick overview, it contains more than 600,000 decisions, most of them being in German, but a considerable part of it in French, and then a smaller part in Italian. On the below, you can see the distribution over the dates. So on the x-axis, you have the number of decisions. So here in 2020, we have 30,000 decisions published in the Swiss German area, and it started at around 500 decisions in 1990. So the second part is that we want to pre-train a Swiss legal BERT. There we have the challenge that many legal documents are very long, so way above the 512 token limit of BERT. In the Swiss court decisions, we have an average of 1K to 10K tokens. So we would propose to pre-train a big BERT model so we can process these longer texts more easily. As data, we have laws, court decisions, and maybe legal articles if we can get a hold of them. That's a bit of a problem because they're not very freely available and in the hands of commercial entities. So open questions here are still if we should include data from Germany, France, or Italy, or other countries which speak one of those languages in an earlier pre-training stage, and also if we should pre-train a multilingual model or monolingual models. Then the third step is to annotate a named entity recognition corpus. So because named entities are anonymized in court decisions, they provide the information if they are not anonymized, so we need to recognize them. And this is a basis for the knowledge graph later on. So here we have some questions which are, which court should we include? Should we build a very broad data set with few annotations per court, or rather a very deep data set with few chords, but a lot of annotations. And then also what categories to annotate. So how fine-grained should it be? As extensions, we could also annotate relations or core references in this corpus. The categories, some of them, we expect them to be easy to annotate, so we can use regular expressions or parsers or crowdsourcing, and others we expect them to be rather hard, so we need to ask lawyers to do them. And then the final step, which is the re-identification. Here we have the following process imagined for the simple solution. So first we extract identifiers from the decisions with named entity recognition and regexes. Then we search external data, so newspaper articles, Twitter, death notices, whatever, wherever we find references to court decisions for these extracted entities, the identifiers. And then we present the external document where we found the identifier to a human re-identifier, which can then perform the final step. So here we have a metric of success, which is the percentage of correctly identified external documents. Then to the complex solution. Here we would first construct a knowledge graph on both the external data and on the court decision, and then perform ontology mapping between the two graphs. If we find an entity being mapped between those two graphs, this would correspond to a re-identification, a possible one. And then we can show this match to a human re-identifier. Here we would measure the success by the percentage of correct matches. So what can the community expect from our work? Apart from the direct contribution of the re-identification tool, we also will generate many open access data sets during our projects containing legal data from Switzerland and also connected external data, which we will pre-process and make available for easy use in the NLP community. Additionally, we will also pre-train the Swiss Legal Bird model, which we will open source as well. So to wrap up, I'm a bit earlier than expected. I'm sorry for that. So we are in the field of a difficult balance between open justice and privacy, and here we plan to perform an empirical study to estimate the effort required for re-identification. And with these results, we hope to produce guidelines for a more effective anonymization procedures. And while performing this research project, we will produce many spillover effects to the community, like datasets and models. So this is it, and I am looking forward to your questions.
Thank you, Mr. Niklaus. The question sent to you is, if I will send to you also in the chat, so you can read it. Just a second. If this is considered a proof of concept, how do you intend to scale? Do you have an estimate time the software takes to anonymize compared to human work to do the same thing?
Thank you very much for the question. So as I see this, these are two questions. So I will first answer the one of the proof of concept. Yes, this is a proof of concept, definitely. we plan to make it as big as possible, but it is a research project and we have limited manpower. So in scaling this solution up is not part of the research project. It might be we might refer this to the Federal Supreme Court, which might develop this further afterwards. And then, do you have an estimated time the software takes to anonymize compared to human work to do the same? So far, we don't have an estimated time, but and also we focus on re-identification and not on anonymization first. So anonymization will only be part of the project in the later stages. But if you are talking about the time it takes to anonymize one decision, this should be very small. So in the range of seconds, we assume.